I've been a judge in one form or another for a while, and it's what Rama mentioned was that a lot of what I do involves things like personal injury and historic child abuse work. So we do get quite a lot of people who are representing themselves sometimes. A lot of cases people have lawyers, but sometimes they don't. And that means, of course, that we see quite a diverse range of people, quite a diverse range of abilities, both in linguistic terms and in disabilities terms. So it's a pretty broad range. And those cases often engage considerations which mean that we have to think about how to make the court process fair, not just in terms of the law, but in terms of actually how we go about conducting hearings. Now, as you'll have heard from Rama, I was one of the editors. It's a big committee, so I don't write the thing, we'll contribute. But I was on the committee for this year's Equal Treatment Bench Book. And it's a very diverse committee. We're drawn by a sort of proper open selection exercise so that lots of different shades of opinion are represented and lots of different types of people from lots of different backgrounds from within the judiciary. So first of all, I'm just going to say a little bit about what the Equal Treatment Bench Book actually is and what it aims to achieve, because it's one of those things that the UK has been doing for quite a while, I think probably at least 10 years. And some other jurisdictions either have or are gradually adopting and expanding their own versions. I think, for example, Australia and New Zealand, for example. So what is it? Well, it's not like a judicial code of conduct. So it's not something that judges have to do or have to abide by. So it isn't a rule book. It's really expressly framed in terms of being guidance to judges from judges, really. The sort of handbook that if you're a judge and something happens or there's a party from a community that you're not familiar with, or an issue comes up that you've never encountered before, and perhaps your colleagues can't help you with, that you've got some resource in place of an expert, I suppose, to turn to, and links, if you like, to take you to explore the issues if something crops up. So it isn't something that, as I say, is like rules. And it's quite important if you think about that, because what we can't do with judges is tell them what to do, because they're independent. And indeed, if we tried to tell them what to do, they would be very unhappy. So it's expressly put in terms of guidance and advice as to what we, the group of people writing it, think is an acceptable or perhaps best practice. And sometimes there is no right answer to that, because there are different views on different subjects. And we try to mention where there is a range of views and give our preferred approach, if you like, but it isn't gospel, it isn't binding. And so I think sometimes it's misunderstood as being a sort of rule book. So in a sense, it tries to modestly give judges who may lack experts or expertise in court on social or cultural factors, at least some pointers to help them when they're actually managing court cases, perhaps when they've actually got the parties there in a trial. But it's more than just a book. It's actually a living document. It's a sort of service, if you like, because it doesn't just get published and then sit there fossilizing. So there are updates periodically, but also if there's some development or some important new issue in society that arises that judges perhaps need to know about, bulletins and so on can be issued in between editions, so that it's more than just if you like, a fossilized textbook. So, for example, in 2020, as you might not be surprised to hear, we issued an urgent update to all judges about the equalities considerations that arise around online court hearings, because obviously the UK switched to almost entirely an online court model. And in fact, I'm sitting in my online court now. It's actually my kitchen with a backdrop off eBay. And I've been conducting my court hearings from my kitchen. But it's important when you're thinking about court hearings that are online to bear in mind the equality and diversity implications of that, because I might be talking to someone in their home. I might not know what kind of pressures they're under, whether there's domestic abuse, whether there are childcare issues, things that I can't tell or I can't see and that one has to be sensitive to try to pick up on, and which wouldn't necessarily be quite so acute if someone had physically got to court. But there could easily be someone off camera. Someone might not feel safe to talk at home, for example. And of course, there are the potential issues around disabilities. Some people who have sensory deficits would be fine in a person-to-person courtroom, but it might be a lot harder for them to deal, for example, with lip reading or to hear over the internet. So there was a need, if you like, for an update to make sure that judges actually bore that in mind, because it wouldn't necessarily occur to them, particularly in the center, if you like, of what was then a building pandemic. So what are the key objectives then of the Equal Treatment Bench Book? Well, what we aim to do is to go beyond just, if you like, complying with what the law says about diversity. That sort of should go without saying, but to focus on, if you like, the lived experience of parties and lawyers and other participants, such as witnesses in court cases, in terms of how they actually experience fairness in court proceedings. Because it's fairly trite to say that if a hearing is unfair, then it's really no hearing at all. Whether or not the law is applied rightly or wrongly, you still have to have fair process. And it's not good for society if people don't feel that they've been properly heard or listened to, or that they're being judged in a way that is, if you like, separate from their own lived experience and doesn't really understand it or have at least some insight or some empathy for it. And the objective of the bench book team, I'm going to put up my first slide, so if you'll bear with me, and I hope this helps, hope it works. There we go. The objective that's stated in the bench book is this: the starting point for this updated work, that's this year's edition, is more than compliance with the prevailing legal framework. The profound desire of the team responsible for this revision is that all those in and using court leave it conscious of having appeared before a fair-minded tribunal. And that goes to the point that I just made about not just legal fairness, but procedural and contextual fairness. So the perception is that justice is being done, as well as simply doing justice in that narrow legal sense of the word. So I'm just going to take that slide off. How then is it actually used in practice? Well, as I've said, it's guidance, but the work has actually increasingly now become a basic standard that advocates, barristers in my country, but avocats or other people who speak for parties in court in other jurisdictions, the standard that the advocates recommend to the court, so that if there's a diversity question, if a party has particular needs, or there's some issue that the advocate feels that the court needs to take into account, it provides a useful basic resource, because it's a public document, and I've sent Rama and Livia links so that you can have copies of it easily. It's out there on the internet. It's there as a resource for advocates as well to refer the judge to, as to at least what a group of judges, the committee who write it, feel is good practice. So it can also provide the judge, of course, with what amounts to at least a defensible resource to justify why they're taking the approach they're taking. And perhaps the most prominent application, and indeed a tacit acceptance that the Equal Treatment Bench Book is something which is a standard that can be relied on in court, came from our own Supreme Court in a case called Serafin and Malkiewicz and others, which was a 2020 case in our Supreme Court, in the context of a case being unfair, or at least the argument that the case had been conducted in an unfair way by the judge, not appreciating the, if you like, the needs of a party in terms of how proficient they were in speaking for themselves in court. And the court there in the Supreme Court quoted from the Equal Treatment Bench Book, and they said that judges may need to assist litigants if they're representing themselves, so as to help them to express themselves in the way that they want to express themselves, and to facilitate that by just not being being a bit rude, not by not interrupting or encouraging or cajoling people in the way that you might do with a professional advocate who's more experienced. So the Supreme Court said this. Put up my second slide when I can find it. The court said this. I'm going to read off my slide screen. Every judge will have experienced difficulty at trial in divining the line between helping the litigant in person to the extent necessary for the adequate articulation of his case on the one hand, and becoming his advocate on the other. The Judicial College, charged with providing training for the judges of England and Wales, has issued an equal treatment bench book. In chapter 1 of the edition, issued in February 2018, this was the previous edition, it's done every 3 years or so, revised March 2020, the college advises judges as follows. Litigants in person may be stressed and worried. They're operating in an alien environment in what is for them effectively a foreign language. They're trying to grasp concepts of law and procedure about which they may have no knowledge, and they may well be experiencing feelings of fear, ignorance, frustration, anger, and bewilderment, and disadvantage, especially if appearing against a represented party. The judge is a facilitator of justice and may need to assist the litigant in person, that's what we call people who are acting for themselves, a litigant in person, in ways that would not be appropriate for a party who's employed a skilled legal advisors or experienced advocates. And this may include not interrupting, engaging in dialogue, indicating a preliminary view, or cutting short an argument in the same way that might be done with a qualified lawyer. And to give you the flavour of, if you like, of what happened in that case and why the court was looking at this, I've got a quote from the transcript of what was actually said by the judge, and there's a lot of it in the judgment you might want to look at, but just a little flavour is that the judge said to the barrister said to the party, "Do you deny saying you were still married?" And then the claimant said, "Well, starting with Miss Pachesny, okay, I was friends with Mr. Pachesny." And then the judge interrupts and says, "I do not want a speech." And then there's a whole schedule of other quotations in the judgment itself. And you can see there that the Supreme Court was led to comment really in terms of the recommendations in the Equal Treatment Bench book about such things as not interrupting or cajoling people in the way that you might where you wanted a professional lawyer to sort of get on with it. Now, Serafin, the case I just referred to, isn't the only case in which the Equal Treatment Bench book has been cited. And this is really part of my illustration of the fact that it's becoming a resource that forms not exactly part of our law, but certainly part of what has been recommended by other courts in terms of best practice. And the next case that where the Equal Treatment Bench book was referred to is a case of MXM, which I'll bring up a quote from now. This judgment starts by saying that decision makers should, where possible, apply the guidance in the Equal Treatment Bench book. This was about gender identity in court now. Courts, decision makers should apply the guidance in the Equal Treatment Bench book and use gender terminology which respects the chosen identity of the claimants before them. Really, that means parties as well, it wouldn't just be claimants. So in other words, respecting the preferred way of being addressed by the court so that people can choose their gender pronouns, or Mr. and Mrs. Ms, or in this case, Mx, a neutral, gender neutral term. The appellant identifies as non-binary, said the court. Having had regard to Chapter 12 of the Equal Treatment Bench book, I began the hearing by asking the appellant what form of address they would like to be used. Note the use of the word they there. The court's deliberately avoiding a gender pronoun there so as to respect the wishes of the party. The appellant requested that I use the gender pronoun mix. I have amended the file accordingly and have used gender neutral terms throughout my decision. So a classic example in quite a senior court, the upper tribunal in the UK, which is an appellate court, endorsing the use of gender neutral terms if that is what is respectful to the relevant party or the witness. And in another case, a family case, a local authority against various individuals whose initials are listed for anonymity, That case also referred to guidance on reasonable adjustments in relation to an autistic party and called the Equal Treatment Bench book, quotes, invaluable. So we've got an increasing base, and there are other decisions one can find online. We've got an increasing base of case law that is citing the Equal Treatment Bench book with approval. And indeed, it's beginning to be taken into account, I think, by others in other jurisdictions who are looking at drafting improvements and amendments to their own Equal Treatment Bench books, and taking into account the fact that this can feed into court case. So I want to look really at what's new in this edition very briefly, because the whole volume was re-edited by the team this year. So in a sense, all of the text has been refreshed, although by no means all of it has actually changed. But just some highlights, because I'm only speaking for a short time today, so I'm just going to put up the highlights of what changed in the last edition, or this edition. So this new edition takes into account the impact of COVID on different groups and how to conduct remote hearings. That's what I referred to last time. That may sadly prove useful in future pandemics and future waves. There's an enhanced emphasis on the bilingualism that one encounters in our courts, because of course it's often forgotten that England, Britain, is actually a multilingual country. We have two official languages, and that's Welsh and English in terms of their status in court. I'm half Welsh myself, but I don't speak Welsh. My mother, though, her first language was Welsh. She had to learn English. And so it's by no means the case that everyone speaks English, although I think certainly there are very few Welsh speakers now who don't speak English. But of course, we're a polylingual society anyway, even aside the Welsh-English language mixture. We have hundreds of different languages, but it's a particular feature of our courts that Welsh can be spoken, especially in Wales. So there's an enhanced section on that bilinguality and the right to conduct hearings in Welsh. There's an overhaul of the section on trans people. That's always a controversial topic, and of course it changes over time. There's a revised section on assisting litigants who have literacy difficulties. There's a great deal more information in terms of terminology, especially in relation to types of medical disability, so that judges know what's being referred to. You might say they could Google it. Yes, they probably could. But some judges prefer to have a book, I suppose, even if it is a digital one. And a significant update in terms of how oaths are taken in court, because historically there's been a bit of a, if you like, a Judeo-Christian focus on oath taking. But of course, we're a poly-religious society in the UK, and there are many different religions, many different faiths, and it's important for judges to be able to look up what sorts of approaches are sensitive and appropriate for different communities. Of course, actually asking people helps, but it's good to actually have some background so that one doesn't ask in ignorance. And there's also some points made around sensitivity over menopausal symptoms, which may affect the ability of witnesses to give evidence or indeed to attend court, and just affect how they feel. So I'll just turn that slide off. So, as I say, this is only a brief talk, and the aim today is perhaps more of a discussion. So I won't do the mercy. I'll do you the mercy of not spending very long on the actual text itself, which of course is publicly available. But I thought I'd just highlight a couple of areas close to my own heart from judicial practice. One of these is the notion, really, that fairness isn't something you do to someone, it's something you do with someone. And that's my own assertion. I don't think that appears in the bench book. But it's an assertion by me that really has two quite deliberate parts. The first stresses that it's a mutual thing. It's not about judging what is fair for someone. It's about involving that person mutually and respectfully in how a case is conducted, or at least trying to put yourself as far as possible in the shoes of the other person. Obviously, you can't walk a mile in somebody else's shoes always, but you can at least try to imagine and try to understand and try to assist them, principally, of course, by listening to what they have to say. And that brings me to the second limb, which of course is that it's an active process. Because it's something you do, not something you are. You're not just a fair person. Fairness is something you have to do. It requires action and sometimes positive steps and positive measures to accommodate people in court, to make them welcome, to make them feel listened to. For example, in the bench book, disability is a big factor. And I remember when I was qualifying, I encountered a situation where there was a student. I was a student then, but there was a student outside an event at the legal training course where there was a careers fair where you would get opportunities to meet people who might give you jobs. A small group of people outside were gathered around a young woman who was in tears in a wheelchair. And this is the mid-1990s. Why? Well, she was a student on the bar course, but she couldn't get in to the careers fair because it was up a flight of stairs and there was no lift. So she'd been excluded from that event, excluded from that career opportunity through a lack of thought by how the building had been built, but also by the organisers. So there can be a real physical effect of not accommodating disability. And it's a key part of the Equal Treatment Bench book to make people aware that sometimes you need to make sometimes non-obvious adjustments. So for example, in my court, I usually make sure that I ask the lawyers whether anyone, a lawyer, a witness, a party, has any adjustments that they need to be made to the physical environment or the way we schedule the case. So for example, someone might be physically able to get to the court, but they might need to have a break occasionally, to have a rest. So for example, if I bring up my 7th slide, which I think is my last slide, the suggestions there are just obvious ones, but it's important to think about them. Impaired mobility, they've got to have access to the courtroom. Physical discomfort, what are the seating arrangements? Do people need to stand up and walk around occasionally because of disability? Do the drinking implements, do the water jugs even provide handles that people can hold? Simple accommodations like this that don't exclude people who are less able in a physical sense. Hearing, the need for induction loops, maybe closing the windows if there's noise outside, and the side effects potentially of medication, or the need occasionally perhaps for breaks to take medication. And indeed, to bear in mind that the stress of a hearing can actually exacerbate symptoms. And there's a whole section of advice in the book. But the nutshell really is that it says, I'll just get rid of my slide so you can see the rest of my face. There you go, lucky you. It does not matter, says the book, whether there's an entire meeting dedicated to discussing proposed adjustments for a disabled person, or whether the discussion is part of a wider case management discussion, but what matters is the subject is explored. And in fact, I invented a type of court hearing at home, which I tend to encourage other judges to use, which is that where, in some of the cases we get, where you have quite complex disability issues, for example, perhaps someone's paralysed, they've been involved in a serious road accident, but they have a right to come to court. They have a right to see their own case and participate as far as they can. Sometimes it's necessary to make quite extensive adaptations. For example, the judge may have to go to a different court. You may have to find a court where there is a private room available, so that if the person who is perhaps needing ongoing medical care and their nurse or carer can have some privacy during a break in the case, perhaps to do with a colostomy bag or other sorts of things, or the administration of medication, those sorts of things that go to the basic decency with which one treats people. And that can require changes to what days of the week, how many days that individual might come to court, what witnesses they feel they need to see, so they don't have to come every day, or perhaps only coming in the afternoon, or perhaps having the hearing nearer their home because of transport difficulties and need to arrange a specialist disabled transport and so on. All of those things can be useful. And I have what I call a disability adaptations appointment, so that if there are relatively involved, relatively complex issues about timetabling the case and making arrangements, we can have a separate discussion, which is separate from the fighting in the case, where we don't discuss the legal issues in the case, we don't discuss the disagreement, but where I expect the lawyers in the case to engage constructively to make sure the case happens in a fair way. And one can separate that out to avoid stigma if that is what the disabled party actually wants. And I've done that a few times, and that's a type of hearing that I pioneered at home. The final area I'll deal with, because there isn't a lot of time left for me, is to do with language, and that is actually how one communicates. It's not just how you communicate in court, but actually how you communicate decisions. A lot of people, of course, don't have English as a first language, or their English isn't to a very high standard, or perhaps their reading isn't to a very high standard, whether or not their first language is in English. So in an ideal world, of course, we would have the facility to translate everything into the first language of the person we're talking about, or to have a third party who could explain in detail what the judgment means if it's not strictly a language or translation issue. But we can't do that. We don't have the resources for that. So chapter 1 of the Equal Treatment Bench book provides a lot of input in terms of types of things that people who are not lawyers might misunderstand, and sometimes how you need to explain the process in simple terms, because to lawyers certain things are obvious, and they're just not to other people. Quite simple. Even very educated people, they're not going to know about certain technical legal processes. Why should they? The lawyers are paid to do that. But one area that I pioneered at home as well is what I call the accessible language summary, so that when I give a judgment now in writing, because some of my judgments are written, some of them are oral, but when they're written, I write the judgment in the normal way, which might have quite technical language in it, but I include at the start a short summary, which is written in simple English, avoiding technicalities and complex sentence structures. And I make sure that the level of English language that you need is appropriate only to an average level of English proficiency. And I use what's known as a FLESH score, FLESCH, which you can run text through anything online to do that, and indeed Word can do it too. So that at the start of the judgment, even if someone's not a lawyer, they should really be able to understand basically what it's about and what the decision was and why. And actually, if you're a judge and you can't do that, perhaps you should worry, because we shouldn't have to necessarily rely on jargon, at least to get the basic point across. And the bench book adopted my basic idea, and it says this: although in the context of represented parties who are vulnerable, Chapter 2 provides interesting examples of family court decisions where there is a particular effort made to communicate with the parties. Another possibility in appropriate cases is to start the judgment with a short and clear accessible summary. And then they give an example of one of my accessible language summaries, which I put in one of my cases, and you can see the quote, the reference to that in chapter 1. It was a case called Just Digital Marketplace, which actually was a very technical judgment about enforcement of judgments, and the question whether you can use, instead of sending around bailiffs or court officers to seize goods to enforce a judgment, whether it's acceptable, if everybody agrees, for that to be dealt with on a video link or by phone, on the basis that the goods are simply notionally seized, they're not physically taken away, but the party has agreed to keep them there, if you like, as security for the judgment, and they can be sold if the debt isn't paid. Now, we already have that process, but the question was, can that be done remotely rather than with a strong man knocking on your door, which can be quite intimidating? And I said that it could be legally. That's an important decision for ordinary people who may owe small amounts of money through the courts, but who wouldn't be in a position to follow the technicalities of why it's legal, which actually go into some quite detailed material about regulations around enforcement. So the accessible language summary in that case, the Just Digital case, is important because it means the ordinary person can understand their rights. And actually it means the press report it accurately, because the press aren't always lawyers. And even people on the internet perhaps can be more capable of talking about it in a more informed way online. Well, I'm coming to the end of my talk. Other areas include, for example, modern slavery, the importance of appreciating the vulnerability of a witness in that situation, the victim or the alleged victim, perhaps the necessity to have separate entrances to the courtroom, maybe separate waiting rooms, maybe screens to stop the victim being stared at by the alleged perpetrator. And there's a lot of material in the book about how to arrange courtrooms and to take measures to protect witnesses in that way. And a lot of data about statistics on the issue of modern slavery and information that tries to ensure that judges don't jump to conclusions, if you like, about the stereotypical kind of person who might be a victim of modern slavery. So it's a pretty rich resource. It's an increasingly long resource, and it's not intended to be read as a book, but it is a reference resource, and it's increasingly a reference resource for judges, but also actually for lawyers and others. So I think I'm going to stop there, and I'll put up another slide just because I expect we're hoping to have some sort of discussion. I expect, and I shall wind up there with about 30 seconds left, I'm pleased to say.
Thank you for your informing presentation, Victoria, and many thanks to Livia for giving me the opportunity to attend this meeting. Zoya Aydın. I spent most of my professional life as a human rights and women's rights lawyer in Turkey, and I would like to start by saying that Victoria's presentation impressed me a lot as someone from a different legal system where there is neither any guide nor reliable justice statistics. It also inspired me to think about multiple ways how I can contribute to the creation of this kind of guide for Turkish system, in particular for women and LGBT peoples, of course, Syrian immigrants in Turkey. When I looked at the bench book, the last revision, I was deeply impressed by its statistical depth and widened scope, but what struck me most was the inclusion of the effects of COVID-19 pandemic on remote hearings and the justice system effectively in such a short time. I really want to congratulate Victoria, as she was one of the editors of this publication. I would like to indicate 3 important points and then ask 3 related questions. As you know, equality and the right to a fair trial are 2 important human rights issues that we have talked about for centuries, which we often refer to, but still do not fully agree on their concrete content. Therefore, I believe creating a guide for judges will contribute to the realization of equality and justice by helping to eliminate this ambiguity. It will allow judges of different backgrounds to be less biased in cases too. I'm sure that the bench book have been increasing awareness and understanding. Victoria mentioned some examples, and I wanted to add some example, the best and most recent example. This was seen in the last 2 cases on transgender rights. The direct reference to this guide in the Maya Forstater case, which is about employment tribunal, and the other one is the judicial review on transgender prisons case, showed how functional this guide was. I read some critics from some think tanks and conservative women organizations have called for a revision of the final version of the bench book. But this example, I believe that this example provided an opportunity to define a basis for judges with an unwritten legal tradition on controversial and ambiguous matters. So with related to it, my first question is there any mechanisms that show how this guidance is implemented and whether the judges follow this guidance or not?
Well, yes, interesting. I've been asked that question before because I gave a talk in New Zealand about this, and I was asked that question then. And in a sense, the only guide we have is where it's mentioned perhaps in an appeal, in that we don't have a system of monitoring. And I think that you've got the internal politics with a small p, in the sense that I suppose judges probably don't want to feel that they're being watched, especially when it comes to something where it's really only guidance. So I suppose we rely on informal feedback. I suppose we rely on people writing to us. We rely on appeal courts. It would be very interesting to know what an impact it actually has. But the only handle we can presently have on it is if it's referred to in judgments, really, because we don't have a system where there's sort of oversight. You know, because we're independent judges. I think judges would be very resistant to feeling that the state, in some sense, was watching them. Even if it was other judges watching them, they would probably totally get lost. Because we're quite robust about protecting our independence. It's a shame, because actually it would be quite nice to know whether practice has improved, and it probably it's just those indirect measures of appeals and whether people are complaining about unfairness. I think is about all we've got to go on, really.
Yeah, thank you. The second point is the disparity between the guide and practice. For example, impunity in the UK judicial system is criticized so often by Amnesty International, particularly custody deaths and rape cases. Despite the Equality Act, which was enacted in 2010, there is lack of trust in judicial system, especially by members of the BAME community. Stated in this book, almost 80, if I'm not wrong, 85% of minorities, particularly Black people, don't trust the justice system in the UK. This rate rises among women, which shouldn't be surprising to us. For this reason, we know that many minority groups, especially in London, set up their justice systems and solve the problems themselves. I witnessed some Kurdish and Turkish groups, this kind of peace commissions. Some think that these structures should be supported due to belief that they will find a better and more effective solution in their own culture. They think UK is a liberal country and give them this kind of opportunity. But I have some concern about it. I would like to indicate this is mostly the case of Muslim groups and traditions, and are maintained mainly against women, girls, and LGBTQ people in the name of this cultural pluralism. I think, in my opinion, this shouldn't be allowed. Therefore, I believe that more measures should be taken for women's free and easy access to the justice system. The correct attitude is that cultural and legal expertises should be more involved in the legal system rather than local justice mechanisms.
That's really interesting. You've covered a lot there. I mean, those are all really important subjects. I mean, starting almost from the end, one of the areas that a lot of people, a lot of commentators in Britain have referred to, as I'm sure you know, is the cutbacks in legal aid. So there's the removal of a lot of funding for people who can't afford court cases of their own, and the suggestion that that has a particular impact on women, especially in abusive relationships and in domestic violence. And there's been a lot of talk around the impact that that has in terms of women's access to courts, which can be perhaps, you know, one of those aggravating factors. In terms of the idea of people doing justice themselves, I think that the really interesting thing there is, obviously, because we're a common law system, we actually accommodate that in the sense that people are, as long as it's not, and this is where the problem is, as long as it's not oppressive and coerced, people are free to engage in whatever kind of dispute resolution they want, and, if you like, set up their own contractual court where they all agree to abide by certain rules and have a trusted person resolve their dispute. And that would be valid under our legal system as long as it results in a valid contract or agreement at the end. And there'll be certain things you couldn't do, such as criminal. We're talking about civil disputes or family disputes. And there's a long tradition of doing that with the religious courts and so on, who form their own dispute resolution mechanisms. The problem, of course, is that you can end up with a situation that particularly can disadvantage women, where you're talking about family and assets.
Yeah.
It's a very difficult tension, that, because these sorts of dispute resolution approaches are really evolved for things like business disputes and rather informal family disputes. But where you're talking about what could lead to an oppressive, even violent situation, that's a real worry. And we have this tension, of course, between the need to allow people the freedom to solve disputes out of court on the one hand, whilst on the other not having a free-for-all where people are effectively locked up and kept away from court. And it's a difficulty, I suppose, of a common law system, that you can do anything as long as it's not illegal, rather than you can do what the law allows. We, if you like, have an automatically permissive system. So we would need to legislate to restrict what can happen in those sorts of dispute resolution situations. Whereas I think in a civil law system, it might be easier, because one can actually have a rule that you can't engage in that and have very defined circumstances where it is allowed. And it's quite an unregulated area. But yes, there's a lot of opportunity in our system to resolve disputes out of court. That's good, but equally that can be a cover for oppression, and that's bad. And of course, there are parts of the Equal Treatment Bench Book which, at least when someone comes in front of a judge, are aimed at helping the judge to spot the signs of coercion. And in the UK, coercive controlling behaviour of a spouse towards a wife has been made a criminal offence recently. It's a form of domestic abuse, which is now recognised in law on the equivalent, if you like, to violence. But in terms of the confidence that minority groups have in our legal system, I think the biggest thing is not advice to judges, and who knows if they follow it, because in a sense that's very much an othering. And I had the experience, because I'm trans myself. When I was editing the book, I was editing a book about, including discussion about what to do to trans people. So it's quite an othering experience to find yourself talked about in a book. I think the best way really to encourage confidence in our judicial system, of course, is to have a diverse judiciary. And there's a long way to go in that. And I think a large part of a lack of confidence among minority groups is probably the fact that the judiciary itself isn't as diverse as the society that it serves. And a lot of judges would, I'm sure, strongly support the idea that we've got to improve that, and that simply having guidance in a book is not going to solve that. It's putting in place some basic stuff to ensure that on the day in court, the judge doesn't make a complete mess of it. But it isn't necessarily going to be even a significant part of the whole answer in terms of restoring confidence, I think.
Lastly, I want to ask, why a justice system with such detailed information and adopts the rule of law as a principle cannot be trusted? What do you think is the reason for this insecurity, and how does this book change that? Before your answer, I would like to mention a very famous case, as it known, Shamima Begum's case. As you know, is the most controversial case, and I'm concerned that it could further contribute to the lack of trust of BAME girls. As you know, the Supreme Court has overruled the appeal court decision that the right to a fair hearing must prevail national security, and held that if a vital public interest, such as public safety, makes it impossible for a case to be fairly heard, that it cannot ordinarily be heard. The criminal justice system, when I looked at the bench book, I saw many places those witnesses under 18 have various other factors, are vulnerable, must take account. So it was criticized because Begum was seemed under 18 kind of sex slavery and kind of victim of sex slavery, and she comes from BAME community. And I remember that at the Guardian editorial site, they criticized the decision. They believe that it's a big threat to discriminate British citizens with ties to other countries differ from those. So fair treatment is a fundamental principle, and we say many times judges are seen to be both independent and impartial. Justice must not only be done, it must be seen to be done. So I observed many BAME community. This decision seems unfairness. So I want to ask my question. What do you think Shamima Begum case will affect this mistreated belief of BAME community?
Well, because I'm a judge, I can't go too much into talking about cases because I'd be understood as criticising or not, criticising or agreeing with the Supreme Court. I don't suppose they care what I think, but I have to be very careful because what I say is public, and we have a convention that but on the general point, I mean, I think that there's an expression that someone once used, which is that in the next world you shall have justice, and in this world we only have the law, or words to that effect. And I think sometimes it's thought that a common law judge or common law jurisdiction, the judges are free to interpret the law so as to achieve a fair result. And that's not always the case. So it can be the case that the law itself produces a result which people feel is unfair, but the judges are stuck having to apply that law. And if necessary, they should say so. But then it's for Parliament to change the law. So fairness only goes so far, in the sense that if a law is harsh, then Parliament is sovereign, because we don't, unlike the Americans, of course, in England, we don't have three co-equal branches. The judiciary are not on an equal standing with the legislature as they are in the US. We have to apply the law. We can't strike down laws. And as a result, ultimately, our judicial system can try to follow a fair process and interpret the law as fairly as we can within the limits of the language. But actually, if a law produces a result that the public or a section of it feel is harsh, and of course opinions are divided. The Guardian is one newspaper. Other newspapers would take I won't name them, but there would be other newspapers saying other things, and I'm going to choose between them. But the public are represented in Parliament, and it's for the government to have to change those laws, and the courts are not equal to Parliament as they would be in the US. We don't have a Supreme Court that has those ultimate powers, which is problematic. I think some of the problems can be alleviated in terms of confidence by better communication, because sometimes I think a decision might be made by a court that sounds like the court is deciding what the law is and saying it is right that this should happen, when actually what a court is doing is saying this has to happen because the law is to this effect. This is what we have to do. And making it clear where responsibility lies if it's felt that the law is wrong or inconsistent. So in the Begum case, I haven't read the judgment, but it sounds like the decision was similar, if you like, to cases a few years ago on the admission of evidence obtained by torture, where the courts said that we, the country, must not participate in or assist with torture or the obtaining of evidence by torture, but they weren't prepared to go so far as to say that we cannot, if we receive evidence and it turns out that it's been obtained by torture, we can't ignore it once we know it. Because if you obtain some information that a nuclear weapon was about to go off, you couldn't simply do nothing, even if it had been obtained by torture, because you know it, you can't unknow it. And that might have been seen, if you like, as a harsh or difficult, philosophically, ethically difficult decision that was made, if you like, simply from the common sense point of view that you might be able to save more people that way, but the state itself shouldn't participate in that. And that's more about, I suppose, realpolitik creeping into the doing of justice in the terms of interpreting the laws that have been enacted by a political body, which takes into account political considerations that courts shouldn't or can't. So it's something for which there isn't an easy answer, other than that it's for the democratic parliament to be lobbied to change the law, because courts can only go so far in our jurisdiction. If we had a Supreme Court that had the powers of the US Supreme Court, we might get a different result, who knows? But again, it might depend on the composition of the Supreme Court, which takes us back to the American situation, where you look at how Supreme Court justices are appointed and what their track record is, and it becomes a whole science of predicting which way they're going to go. So perhaps it just shifts the politics into the courtroom if you do it that way. And maybe the place of politics is perhaps in the elected parliament, because you can remove those people if you disagree with them. But it's not. It's an age-old argument, I suppose. Justice, isn't it? The balance between justice and rules, and how you achieve fairness whilst yet applying rules, and it doesn't always work, I think.